Hasoon, a Senior Associate in the Employment team at Mills Reeve. In this vlog, I'm going to share some thoughts on the Employment Appeal Tribunal decision held in the case of Ms. Despina Charalambos v. the National Bank of Greece. This case serves as a welcome reminder of how the tribunals assess procedural fairness in the context of a conduct dismissal. Now, throughout this video, I'll refer to Ms. Charalambos as the claimant and the Employment Appeal Tribunal as the EAT. So if we start by looking briefly at the background of the case, the claimant was employed by the National Bank of Greece as a relationship manager in its London office. The incident which led to a dismissal centred on an email sent by the claimant to several individuals attaching a spreadsheet. The spreadsheet itself included a breakdown of details of some private clients of the bank and was therefore highly confidential. Now you may be thinking, what's wrong with the bank manager sending banking information by email? Well, unfortunately, two recipients of the email were not employees of the bank. One non-employee recipient was the claimant's trade union representative, and the other was a solicitor who was blind copied into that email. Now for context, the email itself was in relation to two of the claimant's colleagues who were taking voluntary redundancy, and the claimant suggested that she should assume the position of senior relationship manager with salary increase. Now, whilst the claimant's ambition can't be faulted, the execution left a lot to be desired. It later transpired the claimant went on to forward that email to her personal email account and copied a brother in who worked for a different bank, which for obvious reasons was problematic. Once the bank became aware of this, the claimant was suspended. Her manager, Mr. Vathis, then held an initial investigatory meeting with her to understand more about what had gone on. It was then a different manager, Mr. Hood, who went on to have two face-to-face disciplinary meetings with the claimant, and it was Mr. Hood who wrote up a full report, which he then sent on to Mr. Vathis. Crucially though, it was, however, Mr. Vathis who acted as the decision maker and decided to summarily dismiss the claimant without actually meeting her in a disciplinary hearing. The claimant appealed the decision, and the appeal was heard by another employee of the bank, a more senior individual who travelled all the way from the bank's head office in Greece specifically for that purpose. That individual upheld the original decision to dismiss, and therefore the claimant remained dismissed for gross misconduct. So the claimant went on to bring a number of claims against the bank, including whistleblowing and race discrimination. But for this vlog, I'm going to look at how the tribunal dealt with her claim of unfair dismissal. In particular, the assertion by the claimant that the failure of Mr. Vathis to meet with her in a disciplinary meeting rendered the dismissal unfair. So the tribunal dismissed all claims in the first instance, but the claimant was allowed to appeal on whether the dismissal was procedurally fair. Now, the claimant sought to rely on the judgment of a 1976 case called Budgeon & Co v Thomas, and that was as authority for a rule that the dismissing manager had to directly meet with the employee for the dismissal to be fair. However, the EAT disagreed with that, and they found that the key requirements for a fair dismissal had been met despite the claimant not having an opportunity to meet with the decision maker in a disciplinary meeting. So I suppose the question is, well, what did the EAT focus on to form that conclusion? Well, they looked at quite a number of things, but in particular they looked at Mr. Hood's detailed investigation report and the notes of the two face-to-face meetings he had with the claimant, where the claimant was allowed to present any mitigating arguments, and of course the fact that all of this information was provided to Mr. Vathis to support his decision making. Interestingly, the EAT judgment endorsed a paragraph from a leading employment law textbook which queries whether it's always necessary to ensure the person implementing the dismissal carries out the hearing. That extract sets out that fairness can be satisfied where an investigating officer provides a full report, including any potential mitigating factors, to the dismissing manager. In its judgment, the EAT explained that the key point being made in the Budgeon case was that an employee should have an opportunity to explain their position sufficiently prior to a decision being reached. In this particular case, they felt the claimant had had such an opportunity despite not meeting Vista Vathis in a disciplinary meeting. So what are the practical lessons that can be learned from this case? Well, at a high level, it highlights the broad remit that tribunals have when it comes to evaluating fairness in the context of dismissals. It also reminds us of the well-established principle that it's not the role of the tribunal to substitute what it would have done at any stage of the process. More specifically though, this case shows us that a failure to arrange a face-to-face disciplinary hearing between the employee and the decision maker will not automatically render a dismissal unfair. That said, I would avoid seeing this as an invitation to disregard disciplinary meetings between decision makers and employees. Practically speaking, it remains best practice to arrange such a meeting, particularly where dismissal is a potential outcome. In this case, the tribunal reinforces this position when they describe the disciplinary procedure as less than ideal. The EAT go one step further in confirming a meeting between the employee and the dismissing manager is desirable and, in their words, good practice. Another key takeaway from this case is the importance of undertaking a robust appeal process. It's really clear from the fact that the claimant got the opportunity to meet with the individual conducting the appeal that went some way to persuading the tribunal that the overall process was fair. This is not the first case to make clear that procedural imperfections from the investigation or disciplinary stage can be rectified on appeal. Overall, I think this case is a really helpful restatement of the position that demonstrating fairness and reasonableness in the context of a dismissal does not require a rigid or uniform approach. With all that said though, striving to manage a case of misconduct in accordance with best practice and ensuring your own internal policies and procedures seek to reflect that really does represent a solid first line of defence against the litigation risks which can arise out of such dismissals.